Good morning. Happy Friday. One of the comments that I received on my video yesterday about ex parte judicial communications responded to apparently he thinks that I think that Judge Sullivan is the problem in the Flynn trial. And he started off his rather lengthy comment by talking about how General Flynn pled guilty not once but twice. And I want to play a little hypothetical game with you. Just so that we can see how someone might plead guilty. Let's say that you are a young man and you go over to your girlfriend's house and she texts you to come over. You say, yeah, I'll be there in 10 minutes. You bring your cell phone with you. You go to her house. She thinks you're cheating on her or something. You get in an argument. Doesn't matter what it's about, but it's a loud argument. The argument lasts for about an hour. During that period of time, she opens a bottle of wine. She starts drinking. You start drinking. Both of you are drinking wine. Your prints are all over the house. Neighbors can hear you argue. At some point during the evening, let's say that before you get there, she has cut her finger for whatever reason, freshly cut it. Maybe she was cooking herself some dinner and crying, but she accidentally cut her finger. She did, however, bandage her finger up. Over the course of the evening, you've been drinking. She asks you to cut up some apples so that you guys can have some cheese and apples with the wine. Being the good boyfriend and trying to make the argument go away, you decide to do that. So you grab a knife and you cut up apples and cheese so that the two of you can have cheese and apples with your wine. Right towards the end of the night, the argument calms down. She's getting sleepy. She's taken a antihistamine or something like that, which has acted with the wine to make her really tired, really sleepy. And she says to you, as she's sitting there on the couch, we're good. Let's just, why don't you just go home and we'll talk tomorrow. And, I'm over it. I've got it out of my system. I'm just really tired and I want to go to sleep. You say, sure. You bend over to kiss her. She puts her hand on your chest. Now, sometime over the course of the night, the bandage on her finger has slipped off because the wine neither of you notice, and a small drop of her blood gets on the front of your shirt. You give her a kiss. You decide, you go outside to your car to go home, and you decide that you're a little too drunk, so you use Uber. Call up Uber, or you set up Uber on your app. About 10 minutes later, an Uber driver shows up and he drives you home. Next day, you go back to pick up your car. Cops are there. They arrest you for the murder of your girlfriend. Here's what they have. They know you went there. Your car was there. They know roughly what time you went there because of the texts. The girlfriend's roommate arrived home approximately a half hour after you left. She found your girlfriend stabbed, one slice, one stab up through the rib cage into the heart that killed the girlfriend instantly, using the knife that you had cut up the cheese and apples with. Your fingerprints were all over it. Nobody else's fingerprints were on it. There was no sign of forced entry, although the back door was unlocked, but there was no sign of forced entry. The time of death was approximately, as near as they could tell, right around just before you left. Just before, just after, right in that time range. Now, your attorney is going to look at this evidence. Oh, and neighbors heard you guys arguing. It was a loud argument, remember? And it looks like maybe you drugged her because she had that antihistamine in her system with the wine. Oh, and by the way, did I mention that they executed a search warrant and went through your house and they found the shirt with the spot of blood on it that matched her blood. So now you're facing first degree murder. You're facing premeditated murder. Because the way the charging instrument reads is that you had an argument with her, that you coldly and calculatingly planned the murder. You got her drunk, you slipped her the antihistamine to get her to fall asleep, and then as soon as she fell asleep, you stabbed her. And so now they say, hey, there's no evidence of anybody else entering the house. You don't know how they entered the house. You don't know. All you know is you didn't do it. But, I mean, you're not convincing anybody else you didn't do it. Your attorney says that, yeah, they could prove beyond a reasonable doubt that you did it. The time frame of the death matches up. Your prints are on the murder weapon. Her blood was on your shirt. There is clear evidence that you arrived at the house before the murder and that you left the house at around the time of the murder. No sign of forced entry, no other known enemies to your girlfriend. The co-worker has a clear alibi. Or I'm sorry, her roommate has a clear alibi. Let's say her roommate is female and small and wheelchair bound. And immediately had somebody else there with her, dropping her off, a patient, a care worker, someone who actually cares for the roommate. And so, like, a clear alibi, like no way in hell that the roommate killed your girlfriend. So you have a choice. They offer you a plea bargain. You can plea down to let's say you plead down to murder 2, or let's say they'll actually let you plead down to manslaughter. Let's say they'll give you a real good break. So they're taking you all the way down from a sentence that could carry the death penalty to a sentence of maybe 10 years. And they say that as part of their deal, they'll give you 5 years of probation. So all you have to do is serve 5 years and then do 5 years of probation, and then you're good. Would you take the plea deal? Would you risk a possible death sentence? Or would you take the known 5 years in prison and 5 years of probation? My point is that innocent people plead guilty all the time. It is a known phenomenon. It is an unfortunate part of our justice system, which, while it isn't perfect, it is the best system of justice that is currently used or known to man. So, yes, Sullivan is the issue in the Flynn trial. What we have at the Flynn trial, the big parts that really make it clear that Sullivan is the issue is that the state and the defendant both agree to dismiss the case with prejudice. They both agree. Think about that. Think about in any other context where the judge would say, no, you can't do that. Let's say, for example, if you wanted to get a divorce from your wife and then both you and your wife reconciled, and the judge said, no, you guys started this proceeding, you guys got to finish it. That wouldn't be right, would it? Let's say that you sued a business associate for breach of contract, and then you realize that you just misplaced the check that your business associate had paid you according to the terms of the contract, and you want to dismiss it, and your business associate wants to dismiss it. Everybody wants to dismiss it. And the judge says, no, both of you have got to pay for lawyers and continue with this charade all the way through conclusion. That wouldn't be right. And in General Flynn's case, I want to point out a couple things. It's not just that the state wants to dismiss it and the defendant wants to dismiss it, both with prejudice. It's that General Flynn's business partner who was accused of exactly the same crimes and who Flynn was supposed to testify against, was found as a matter of law. That the allegations made as a matter of law did not arise to a crime. The allegations made did not arise to a crime. As a matter of law, had not committed a crime. That means that General Flynn, who was charged with the same thing, with the same facts, also, as a matter of law, could not be guilty. There was no crime committed. As a matter of law, there's no crime committed. In addition to that, you've had, I think, 4 Brady violations. A Brady violation is where the prosecution refuses to or fails to disclose exculpatory information. Information that would tend to show the innocence of the defendant. I believe there have been 4 separate Brady dumps where the prosecution has said, oh, we didn't disclose this exculpatory information. Here you go. There might have been 3. I know that I'm 99.9% positive there were more than 2. I think it was 4. But even one is one too many. Normally what would happen is maybe there'd be some sort of a rehearing, but any way you slice it, let's go back to my hypothetical where you were being charged with the murder of your girlfriend and you plead guilty. And then the prosecution comes in and says, oh, you know what? We didn't tell you this, but there was surveillance camera footage from a neighbor's house that shows some guy dressed all in black, head to toe in black with a hoodie, full face cover, wearing gloves. It shows him going into your girlfriend's backyard. Right at the time you were walking out the front door. I mean, you guys just passed each other. Would you want to change your plea from guilty to not guilty? Would you want to do that? I assume you would. Do you think there should be some sort of maybe a rehearing or something along those lines if that information was suddenly made available? What if at that point you said to the judge, Your Honor, I would like to retract my plea, my guilty plea, and the judge said, well, I don't know. I mean, I asked you twice specifically, and you said under oath that you were pleading guilty. But Your Honor, they just showed that another person entered my girlfriend's backyard right at the time I was leaving. That person could have done it. I don't think so. I don't know, says the judge. And then a month later, the prosecution says, oh, by the way, we actually found this bloody glove that matches the bloody glove that matches the glove that was worn by the person in the surveillance video. We found it 2 blocks away. And we did see on surveillance footage the same person exit the backyard about 5 minutes after you were picked up by your Uber driver, exit and go that direction. Now you say, Your Honor, I really want to take back my guilty plea. And prosecution says, you know what, Your Honor, we actually think that he's innocent, and we would like to dismiss this case with prejudice. And the judge says, you know what? I don't think so. I think I'm going to get another lawyer in here, a lawyer who has already written that I shouldn't drop this case. I'm going to get that other lawyer in here to argue why I shouldn't allow you to dismiss this case with prejudice. And then while you're waiting for that motion to be heard, the prosecution comes back with more Brady evidence. They arrested someone in the area who has actually confessed to the murder. You're saying, surely, Your Honor, surely at this point you will grant my motion. That's like 3 Brady violations right there. That I'm assuming they had all this information just for the purpose of my story before the guilty plea or sometime shortly thereafter. And they held on to it. But you'd say, surely at this point, I should be allowed to dismiss this case with prejudice. And then the judge says to you, you know, I read an article in the New York Post that says you're guilty, and I received a letter from the other guy's attorney that said the other guy didn't do it, and so I don't think he did it. So I'm going to continue to make you go along with this charade and, prove to me why you should have this case dismissed with prejudice. I mean, when you actually take the politics out of what Sullivan is doing, there is a huge problem there. There is a huge problem. In any other case, if a judge was taking ex parte communications as fact, if he was taking news articles as fact, if he was bringing in an amicus to argue against what the plaintiff or the prosecution and the defendant were both requesting, if the judge himself filed an appeal in the case, if the judge retained an attorney to argue for the judge's position in the case, if the en banc Court of Appeals hadn't sidestepped entirely the impropriety of what Sullivan was doing by filing an appeal, because he's not a party. He's just so everybody's aware, when you file an appeal in a case, I've done this a couple times now, you actually are filing an appeal. It would be titled something along the lines of Smith versus Superior Court. And the named appellee is going to be the judge. But then there's the real party. The real party for the appeal is going to be the person who prevailed in the lower court. So the judge is a party in name only. It's like you're saying the judge's decision was wrong, so it's kind of you going against the judge, but the judges never take part in it. I've never seen a judge take part in it. This is completely novel. I've never heard of a judge taking part of it. Only Sullivan's the only judge I've ever heard of. I've read a lot of appellate opinions. I've read countless appellate opinions and Supreme Court opinions and the like, and it does not happen. The judge, the trial judge, does not appeal and specifically does not appeal a decision of the appellate court to an en banc court. That doesn't happen. So I'm sorry, but yes, in the Flynn trial, Sullivan is the problem. Sullivan is a partisan hack, and I hate to speak poorly of him, but there is no other rational explanation for it. Judges may require in a prosecution that if the prosecution wants to dismiss without prejudice, the judge may request that he have a hearing on why it should be without prejudice, because the prosecution may be doing it just to file repetitive causes of action against the defendant to beat him up, monetarily speaking, without ever having to take the case to conclusion. And so to prevent that kind of harm to the defendant, the judge may want to know why it's being dismissed without prejudice instead of with prejudice. Without prejudice means it can be brought again. With prejudice means that it's done. It's considered adjudicated. It's res judicata. You can never bring it back. So judges may do that, but when both parties want to drop it with prejudice, there is no logical reason for it. There's no logical reason for an amicus in a criminal trial to come in and argue against it. There is no reason for it. If the judge did not have a vested interest in it, the judge would not have appealed the appellate court decision to the en banc. The judge would not have hired an attorney to argue his point to the en banc panel. So I'm sorry, he's clearly partisan, he's clearly biased, and for the love of God, I do hope that at some point he is impeached, because that's, unfortunately or fortunately, I mean, it depends on the way you look at it, federal judges are appointed for life, and the only way to get rid of him is if he retires or if he's impeached, and I do hope he's impeached. Anyway, thanks for watching. Have a great day.